Quiet, quiet class. This is amazing Toyin. When you were a kid, you probably heard that word several times when you're in class. Remember when you're in class and the teacher walks in and everybody's going, ah, the whole class is up, and the teacher walks in and says, quiet, quiet, please. Well, today's topic is quiet title. So I'm sure we all know what title means, right? Every property has a title, and the title holder is the owner. So title is a means of controlling property. And we all know what quiet means. It means zip it, right? So this is zip it. Okay? Title means owner, ownership, right? In a way. So when you combine zip it with ownership, it means don't fuck with me, right? Don't screw with me. I own it. That's what quiet title means. Every property in this country has some form of ownership, right? And it's the title. So in other words, when I want to sell my property, I take the title and I transfer it to somebody else. In some places, in some counties, some states, it's called grant. So I grant deed. The deed, which is the same as the title, the deed to the property, and I now grant it to somebody else. So that means I voluntarily relinquished my ownership in this property and I gave it to somebody else. So let's draw a piece of property here. Okay, so my name is Toyin, and transfer title to say John voluntarily. And so when this, as long as it's done voluntarily, this word doesn't apply. Excuse me. But if for some reason John tricked me into taking my property, right, or fraudulently induced me to give him my property, right, or defrauded me to give him my property, I can now seek redress by going to the court. Okay, I will now ask the court to tell John, let me use another, so I'll ask the court to tell John to get the F off my property, right? That's what it means. The court will now tell John, get the F out of his property. I don't really want to swear. In other words, I will file an action in court known as quiet title action. Okay, it's a procedure. It's a civil lawsuit. That's really what it is. It's a lawsuit asking the court, okay, to tell John or give a judgment to the effect that John has nothing to do with my property, number one, has no claim on my property. Okay, and so the procedure takes a while because it's just same as filing a regular lawsuit. It goes through all standard civil procedures, right? As in, taking the state of California, for which I'm very familiar, right? Now, so quiet title action can result from several different angles, okay, in which one party is asking the court to kick another party off the property so that they can enjoy the property by themselves in quiet, solitude, no. Okay, so that everybody else that is yelling, hey, it's my property, the judge will say, shh, zip it, quiet. Title belongs to Toyin. That's what quiet title is in its simplest form, right? So I'm just give you other examples, and I'll then tell you how I came about this. So before I forget, so I'm going to write the word here, tax, right? So let me give you another example. Because I've had people call me and say to me, well, we're getting divorced. I want to sell the property. My husband will not agree with me. And we have some equity in it. I want to take my equity and move. And I said to them, go to court, right? Go to court, and the court will either force him to sell, okay, or the court could tell him that, here, you know what, John, or your husband, you have nothing to do with this property, out. In which case, you could file a quiet title action, okay? There's another action which you could file to force a sale. But if you want to enjoy the property for yourself, and you will say to the court, well, first of all, I bought this property before he came along, so I don't even want him to be part of the property. So I want to file a quiet title action to get him off my property. They will look at the circumstances, look at all the evidence, you guys go to trial, and the judge will rule, okay? And so, all kinds of scenario, the sole objective of a quiet title action is to ask the court to give you complete control of your property, okay, to the exclusion of everybody else that might want to have a claim on the property, okay? So how did I come about this? Very simple. When I first started in real estate, like a lot of people do, okay, I'm sure you've seen all those commercials that says come and buy tax defaulted properties, right? Well, I watched them too. And so one day I went to the tax sale, long time ago. It was at my beginning, right? And since then, I've never bought a tax sale property. And I'll tell you why. So I went there, so I took my credit card, as usual. In those days, I had no money, barely got out of college. So I took my credit card in my pocket. I had a few credit cards. And I went to this tax sale in Riverside County. And prior to that, I had checked the properties. I drove by, looked at the properties, checked the property lines, because they were all pieces of land. And so based on my comps, I figured I could sell each piece for about $6,000. So I took my credit card, went to this tax sale, and I think I bought 6 of them for $1,000 a piece. So that day I spent $6,000 on my credit card. And so I sat on it for a while. I started advertising it for a while. I didn't get a lot of traction because I was trying to sell them for $6,000. So I think eventually I reduced it, okay? And so this guy came, he wanted to buy a few of them all together. And I took his offer and we went into escrow. So when we got into escrow, everything was going fine. The pool title and escrow was going fine. And then boom, the title company says they will not issue title insurance. No title insurance. So without title insurance, I was dead in the water. The new owner, in order for you to transfer title to somebody, right? Especially if that person is going to get a loan, well, you have to have title insurance. And if you don't have title insurance, the escrow is not going to close. Here, it's called escrow. In some other parts of the country, it's called settlement, right? And you have attorneys that do the settlement. Here we have third-party escrow companies that do it, or the title company. And so they said they will not issue title insurance. So I called the title officer. Hey, I got money on this thing. What do you mean you're not going to issue insurance? So she explained to me, well, you bought it in a tax sale. When you bought it, if you read your contract, it says no warranties. Okay? Either verbally or in writing. You are on your own. Because the owners that own the property have certain number of years to come back. Okay? And I just found out actually recently, say for example, in some counties, they have up to 1 year to file a claim, and then the county have another year before they resolve everything. But even then, after that, the title company don't have to insure it because the owner can show up at any time, okay? Even if the 2 years has passed, the owner can show up and say, guess what? The title, the county screwed up when they sold my property. And I have one going on right now. Okay? That we just uh, begin the process of asking the county, how did you come about to sell this property when you didn't even let us know, right? So the owner can come back and say to the county, well, you have no right. Okay, so county tax sale. So it's a tax sale right here. So come back to the county and say, you have no right to sell my property. Okay, and I bought the property. This is me right here, bought the property. But I couldn't get title insurance in order to sell it to John. And so the title company told me, go and file a quiet title action. Have the judge declare that nobody else besides you has a right to this property that you bought in a tax sale. And what do I have to do? I had to file a lawsuit and sue the owner of the property. Okay? The previous owner, and A through Z, and the doors, the heirs, the relatives, anybody else that could be related to the owners that may have passed away. I filed a lawsuit and named all of them. Usually when you name people you don't know, you just put A through Z, John Doe's, right? And all the John Doe's. Now, before I could file a lawsuit, since I was a novice, I didn't know nothing, I went to some lawyers. I said, well, I need to file a quiet title action. Some lawyers actually told me they have no clue what it is. So what is that? You know? So after going to 3 lawyers, 4 wanted me to put down $1,500. I bought the damn property for $1,000. Now I need $1,500 to file a lawsuit. Then I went to the other lawyer, another lawyer. It was the same thing. One asked me for $5,000. I was like laughing. So I finally went to the 3rd lawyer, and he says, well, I'll take about $1,000 down and file the lawsuit. If somebody shows up and fights it, he could run you another $10,000. What? Oh, I said, forget it. So I left. And what did I do? I went to the library. Okay? In those days, there were no internet. So I went to the law library, which was across from the courthouse. And I told the lady, librarian, I need something regarding quiet title action. Then she said, why? I said, I need to file a quiet title action. So she gave me this book. And in the book is the template. We see all these lawyers, they all went to school, right? You know what they teach them in school? Theory. Most of them have no clue after they leave school because they still have to practice. That's why they call it practice. They go to practice, they have to go to the library and get the same template that I will use. So I got the template, and in the template, line by line, okay, it told me exactly what I need to do, including the words, right, and the sentences. In fact, I just went to the copy machine, okay? I copied the whole thing and then translated it into what I know in those days as a pleading paper. Word for word, because the template is available for everybody. That's exactly what the lawyers do. When they do a pleading, they just take it from one template to the other and then they file it with court. It's called a procedure, right? Civil procedure. And so the pleading means I stated, hey, my name is Toyin, although I live in this county. And this property is in this county, and I'm here, your honor, to ask the court to declare that I'm the owner in simple fee, right? Simple fee means some form of ownership to where nobody else has anything in it, right? I think that's what simple fee means. I gotta check that out, but that's simple fee. That's what it means. Total ownership, I think. I'm the owner in simple fee of this piece of land, and then you describe it. It was like 2 pages. So I filed it. And then I had to serve the people. But how do you serve dead people? They're dead. Because I couldn't find the owners. So I began to research the addresses. In those days, there's no internet. You can't Google anything. So I had to go to the yellow pages. I went to yellow pages. I finally traced these people down to San Diego. So I went to San Diego, knocked on the door. They were not there. So all this process that I was doing, this took me 6 months just to even try to find the owner, so serve them. So I couldn't serve them. So then I went back to the court and said, look, Your Honor, I've been looking for these people forever. I've been all over the world. I couldn't find them. They're either dead or drowned, or I don't know. But they disappeared from the face of the earth. So the judge says to me, you have to do a publication. Publication means that you have to serve them by public notice. And so once you serve somebody by public notice, especially at times people try to refuse service. So the court will advise you serve them by public notice. You put it in the paper for about 6 weeks, I think, 6 weeks. If they didn't read the paper, that's their fault, you know. And so I now went, in the paper for 6 weeks, served them, and then I took the service, the proof of publication for 6 weeks, filed it with the court, and I think about 3 months later, I filed my judgment, and the judge signed it. That was when I finally got title insurance. And the judgment just says, quiet title, the court declared that this property belongs to Toyin Daodo in fee simple and whatnot, and nobody else has anything to do with it. And if you show your face, since you didn't show your face 6 months ago when I publicized that you should show your face, you can forever now zip it, keep quiet, boom. Okay? Don't even show your face, period. Can't say nothing. So that's what quiet title is. So be careful. Anytime somebody wants to screw with you as far as your property, right? If you own the property, they're the one that has to really file a quiet title action. Okay? If you have a property that you're disputing and you already know you own it and somebody's trying to screw with you, you could file this action and tell the judge to tell them to F off. This is a class. I can swear in class. So I hope you guys understand it, okay? That's quiet title action. That's the lesson for today. And this amazing Toyin, you can usually find me at amazingtoyin.com or gicdealfinders.com or the magic of real estate. All right? See you guys at the top, and bye.